Thank you everyone for being here. My name is Cassidy Norton. I'm today's moderator. I am the publisher of Banker and Tradesman, and I am also a member of the ZBA in my current town of residence in Woodstock, Connecticut. I have a personal interest in this topic. So we will be talking today with Salim Furth, who is, sorry, I lost it. Senior Research Fellow and Director of the Urbanity Project at George Mason University and Pioneer Visiting Fellow, and Andrew Mikula, who is the Senior Fellow in Housing at Pioneer Institute. And so there will be a question and answer session at the end. So if you, the participants, would like to add your questions into the Q&A setup while we're going through this, we will take a look at those at the end and answer as many as we can before we run out of time. All right, so we're going to, because this is a very complicated topic, we're going to take a quick step back and look at how the Massachusetts housing regulations have gotten to the point that they're at, and then we can go into how best to address those issues as per Salim and Andrew's most recent paper. Andrew, do you want to take this one?
Sure. So, especially in the past few decades, as land values have risen and projects have necessarily gotten, more complex and larger as a result, an increasing portion of housing developments that are proposed are required to go through discretionary local review processes that tend to inject a lot of uncertainty into the process on whether they can be built. And as a result, a 2016 Trulia study found that, between 1996 and 2016, building permit approvals took an average of 9.3 months in Greater Boston to approve. And of the 100 metros included in the study, only 11 had a longer average approval period, including New York and San Francisco. Even more recently, Pew Research Center came out with a public opinion poll of Americans in 2023, and the housing reform in the poll that was the most popular was requiring the permitting process to be faster. So there's growing attention to the idea that in order to meet all of our housing challenges in Massachusetts, it needs to not only be more efficient and speedy process of getting housing approved, but it also needs to be clear what and where you can and can't build in advance.
And that's something that you guys called out in the paper, is that it's not equitable between town to town, what they define as single family home and what someone else defines as single family home. So, okay. You guys want to tell us a little bit more about the conclusions you have reached from your most recent research?
Sure. So, as Cassidy told you all in the intro, although I'm a Massachusetts native, I now live and work in the DC area. And so this research effort that Andrew and I did in the Bay State, I've done, and my colleagues have in several other states where we're working on more now, because the reality is that all happy families are alike, and each unhappy family knows its own unhappiness. So you can't improve permitting processes and reduce uncertainty with the same formula around the country. Each state has a just completely different process for getting stuff approved. And I think there's some really interesting, unique things about Massachusetts. So one is the reliance on special permits. And if you're mostly familiar with the city of Boston, you'll know that everything is done through variances in the city of Boston. This particular paper, we didn't look at Boston. That's been studied more and is really unique, has different powers, is governed under different parts of state law. But if you go to the rest of the cities and towns, as many of you know, special permits are a really big deal. And we kind of quantified those. And we have a few theories as to why that might be. So part of that, although we saw special permit reliance both in cities and towns, part of it might be kind of the traditional reliance on town meeting, and the until the Baker reforms, housing choice a few years ago, the difficulty, right? You needed a 2/3 majority to rezone. So while in a lot of other states, rezonings via the plan unit development process are the normal way of departing from, hey, this is what it says in the base by right code, but we're going to let you do something different. Massachusetts doesn't usually do that because it's really hard to do mechanically, procedurally. And so instead, everything gets funneled through special permits, which I think, I understand why it's done, and I wouldn't want to go in and break it if that's the way that things are getting done. But it's also pretty far from what the state contemplated when it gave towns and cities the zoning power. And the process for special permits is not especially clear legislatively or legally, and is not especially easy. One of the most straightforward reforms that we suggest in our paper is to allow special permits to be approved with a simple instead of a supermajority. And that would bring those much more in line with where the state kind of intended to go with those housing choice reforms several years ago. But the reality is those don't affect most projects, as most things aren't going through rezoning, they're going through special permits. And so we need to bring the simple majority vote, which again, most of the United States does simple majority. Massachusetts is really unique with a supermajority requirement. Um, bring simple majorities to the special permit process, and that's just one of, I think like a dozen specific technical suggestions that we have in the paper.
Is that something, sorry, that what are the mechanisms of getting that approved? Does the town need to super majority vote on its ability to do a simple vote, or does the state, command that they do so? How does that work?
So
Yeah. Oh, go ahead, Andrew.
sorry. In this paper, Salim and I really emphasize changes to state law in areas where the state is already setting the guardrails around how local permitting processes play out. Um, and so I think the state already sets the vote threshold needed for a special permit granting authority to approve a project. In some narrow scenarios, it already is a simple majority, but that's mostly transit oriented or mixed use properties. I believe at least the transit oriented one needs to have an affordability component in order to qualify for the simple majority. But we're essentially recommending expanding the breadth of uh, projects that can qualify for that simple majority threshold. And so, the method by which this happens is, it would have to be a statutory change of legislation that adjusts some of the specifications already in state law to reflect the fact that the permitting process needs to be easier if we're going to solve all our housing challenges in Massachusetts.
Okay. Sorry, I got distracted by the Q&A. All right. So should we take it to more specific types of buildings and how those are permitted, the single family subdivision versus multifamily buildings and the challenges inherent in one versus the other?
Yeah, there's a bunch of differences. So the one thing that's easy to do in Massachusetts is the thing that planning school would tell you you should do less of, which is building single family homes along existing main roads, right? Where every driveway opens onto the main road, which is an opportunity for dangerous accidents with people going at high speed past the driveway. It's hard to do walkability when you're on a main road, and you end up with a kind of splintered public realm. Again, I wouldn't say stop it, but it's not the greatest way to build a city or a suburb. But that's the thing that you can do in Massachusetts under the approval not required rubric. And approval not required doesn't mean you don't actually need approval. It just means the approvals are easier, and you can basically do that as a matter of right as long as you abide by some technical guidelines. Anything else you want to do, if you want to build a subdivision, so if you want to have a new cul-de-sac or a road that connects two roads and build houses along that, well, that's a whole lot harder. And it makes sense that that's something that, a town would want to have more input into. If you're going to build a new road, well, that's going to be there forever. The reality is a house or a house lot, once you subdivide land, that's also kind of there forever. And then similarly with multifamily, then you're not worried so much about subdivision because you're leaving the land whole, but you have a lot to worry about on site plan review. And although that's, again, supposed to be a technical review where the town looks at, is the ingress and egress from your parking lot safe? Are you handling stormwater appropriately? It often devolves into kind of aesthetic nitpicking, and illegal conditions. And so the way that we did this research was we just interviewed market participants. So developers, town officials, land use lawyers. Land use lawyers are great. Any land use lawyers on here, thank you for your service. They're like divorce lawyers, in that they see everyone's mess. And so what these folks told us was that towns will just attach illegal conditions. They'll say, if you took us to court, I'm sure you'll win, but you're not going to want to spend a year in court to save yourself, the 10 or 20,000 bucks that our illegal condition is adding to your project. And that adds up, right? Is essentially the choice is, are you going to spend a lot of time in court, or are you going to, do this thing? So I think we could sort of divide a lot of our suggestions. Some of them were about streamlining little technicalities like the supermajority vote. Some are about clarifying existing law, especially around site plan review, which is not provided for anywhere in Commonwealth statute. And then another bucket is about dealing with appeals, right? People need access to justice. Not everything is fair. Not every market participant abides by the law. And you need to have a judiciary process. But if if the access to justice is you have to spend a year or two in court and lose a huge amount of money doing it, you functionally don't have access. And that's important for private citizens, towns, and developers to have quick and clear resolution when there are legal conflicts about development. Andrew, do you want to talk about some of the ideas we had around site plan review?
Sure. So, right now, site plan review is not really codified in state law. It's something that most towns will do. And what it's supposed to be is, a technical process where you look at whether the proposed project has sufficient drainage and internal circulation of vehicles and other site level considerations. But notably, again, the state doesn't explicitly give towns permission to conduct site plan reviews, nor does it place any guardrails around, what a site plan review can consider or when you can conduct one. This should be fixed, right? In our opinion, the statute should say that towns can conduct site plan reviews, but that they should be limited to a certain set of criteria and that they should be conducted by administrative staff, right? So unlike a special permit, no board vote, no discretion. It should be like building codes, a matter of technical compliance. And of course, for larger and more complicated projects, some discretion may be warranted under different review procedures. But the state can play a role in limiting the risk that site plan reviews get conflated with more abstract, discretionary, often aesthetic review criteria.
Right. And so that administrative piece, that's a really important distinction. Because, there are professionals disagree, right, about is this slope sufficient, or, do we have the right amount of gravel to support the weight of our parking lot? Like those things can be hammered out between professionals on both sides of the table. But most stuff in Massachusetts, even if it's supposed to be technical, ends up in front of a room full of concerned citizens. And concerned citizens, like there's an important place for their voice in the planning process and the rezoning process. But separating that from the technical reviews, we think is really important. Because right now, a site plan review or a special permit or a lot of other areas, which again are supposed to be technical and professional questions, have a hearing requirement attached. And there isn't really a good reason to say, say if you're talking about stormwater runoff, right? There's just technical issues about how much land at what slope and with what types of soils can absorb, the like 50-year projected stormwater. Um, that is like I as a neighbor just have no insight into whether or not the soils here are one type or another. And inviting me to go in and give my opinion makes it, first of all, just takes a huge amount of time. And we can talk more about the repeated hearing process, which is another, unique little purgatory in Massachusetts. But the like once you're there, and if you're on a board, as I know some of our attendees today serve on zoning or planning boards. Once you're there in the room and you've got your neighbors, raising concerns which aren't supposed to be what you're talking about, like as a human being and as a neighbor and a citizen, like you want to address the things that people are raising. And so there's this natural inclination to say, well, yeah, you're right. The aesthetics here aren't great, or we should talk about the landscape screening. Um, but if that's not actually part of what's under review, then it's inappropriate and adds this layer of delay. Not that there's no time to address that, but that this is not the time. And so what we find is that things are getting addressed again and again and again, um, because it's just whatever, if you invite the public to show up, the public is just going to bring whatever they want to talk about. They're not going to stay germane to a technical topic. And I think drawing clearer lines between politics, where everyone's opinion matters, and like it doesn't matter how outlandish or unique your view might be, but like you're a member of the civics here, and you get to say your piece, versus the technical questions of like, are the sight lines going to be safe when these two roads meet? Um, and so eliminating hearing requirements where they are inappropriate, as with site plan review, I think would be a huge step forward. And then secondly, and this is actually one of my favorite suggestions we have. This is maybe the smallest bore, but like potentially hugely impactful. Right now in Massachusetts, anytime you schedule a hearing, you have to give 14 days notice. And for the first hearing, that's appropriate. People need to find out that something's happening. You need time for kind of the neighborhood gossip to percolate, people to inform themselves a little bit. But then the thing, this, like I said, special purgatory, Massachusetts tends to have hearings that go on forever. So notionally, legally, a hearing might last 18 months. And although it meets again and again, it is technically the same hearing. Each of those instances of the same hearing end up needing this 14-day notice. And so you might have like, in hearing number 3, the fire chief asks the developer for some technical piece of information. And the developer says, well, I have to go look that up and figure that out. And then in 2 days, the developer has the information. But to present it back to the board and the fire chief and everybody, he can't just like email. It's got to be in a public forum. And so then you need 14 days notice to reconvene for hearing edition number 4 for the developer to transmit this simple piece of information to the fire chief. And then they discuss it, then they reschedule for hearing number 5. And just shortening that 14-day notice window, right? Take that down to like 5 days or something. Once you're in the repeated hearing process, and allow these meetings to happen, right? Because they often happen on a 2-week schedule that the planning board or zoning board meets, or maybe a 4-week schedule, making sure that whenever the board meets next, we're going to be able to continue, and we don't have to skip meetings because of the notice requirement. I think that's the simplest thing, does not gore anybody's ox, and would just take every one of these discretionary hearing type processes and speed it up a little bit, and kind of summing that across all of the little projects in all of the towns across the Commonwealth would add up to a pretty big invisible change.
I'm glad you mentioned that, Salim, because this is my favorite recommendation of ours too. It's just the classic example I give of why the state's guardrails around the local permitting process need to be updated. I mean, local control is such a third rail in Massachusetts politics that when you have an opportunity to move the needle on something like residential permitting without really, that's kind of within the scope of the state's jurisdiction already, that's really powerful. And I'd also like to emphasize that, you know, the actual language of state law currently is around this 14-day notice requirement. Why it was put in place is so that in 2 subsequent weeks, you could have the notification that there's a public hearing in the local newspaper. And unfortunately, most cities and towns don't have their own local newspapers anymore. And in the internet age, 14 days is kind of a long time, especially when a given hearing, as you mentioned, is often carried over from prior meetings about the same project. So at the very least, we did say 5-day notice period for second and subsequent hearing sessions on a given project. And maybe you could even replace the local newspaper requirement with a post on the town website and/or email listserv of interested residents or something a little more 21st century.
Right.
Um,
Another area, Andrew, where the state is the one deciding the architecture is on all these appeals, right? That the towns and cities have no ability to decide their own appeals processes. So there's a bewildering number of venues, right? If you say, "Oh no, we're in court about a land use matter," you could be anywhere. So do you want to like just sketch that out in a way that doesn't put everyone to sleep?
Okay, I'll try my best. It's so anytime an abutter sues a developer or a local board that just approved a project, their lawyer is going to do everything they can to steer the project towards a general superior court, where you're less likely to have judges that have an expertise in land use law, and therefore you're more likely to have a drawn out decision making process, especially, around cases where it's kind of ambiguous whether the plaintiff's claims of harm are plausible or not. And so one thing you could do that we recommend to make the appeals process less onerous is to allow defendants to choose or even kind of statutorily require certain land use cases to be heard in kind of specialty venues where there is more land use expertise among judges. And that could be land court, which is also a type of superior court, or, it could be the Housing Appeals Committee, which currently hears appeals related to Chapter 40B, and theoretically could be the default venue for cases in which the developer is the one suing. And by the way, there are also requirements that could apply to the abutters or the plaintiff in general to ensure that they are not using lawsuits to merely as a delay tactic or to secure exactions from the defendant, often a developer, but sometimes also the local board or committee that approved the project. And
Yeah,
so,
sorry, Andrew. I'm just going to jump in on top of you there. Yeah, that was one thing I wanted to bring up is there's a note that you guys have made in the paper that butters appealing a land use decision should be required to submit a written opinion by a certified professional to substantiate allegations of harm, which would be a wild cultural shift for Massachusetts in their housing process. So do we think that is feasible or reasonable?
I think in certain cases where the allegation of harm by the plaintiff is a theoretically at least a technical matter, that could make a lot of sense. I'm not going to comment on the political feasibility of that, but I am going to say if your complaint as a neighbor to the proposed project is um, there's insufficient drainage on this site, and as a result, if you build it, my property is going to be flooded. That's something where you could get an engineer to either corroborate that, or you could have a lot of trouble finding an engineer who would corroborate that. In which case, that says something powerful to the judge, who in all likelihood doesn't have that technical expertise. And relatedly, I mean, when you have requirements on abutters to ensure that this isn't just a delay tactic, this isn't just, it's not really about the drainage. Um, you could have requirements for posting bonds, the plaintiff posting bonds. And this is an area where a lot has changed in the last year or so in Massachusetts to the Affordable Homes Act. So, I mean, I think the culture shift in a way is already happening. And judges have, discretion to have plaintiffs post bond requirements, although it is unclear exactly how widespread that practice is going to be. And one thing we said in the paper is there should be a default bond requirement that the judge can then adjust depending on the circumstances. Plaintiffs will usually get their bonds back unless they clearly acted in bad faith by bringing the lawsuit.
Right. Yeah, so I want to chime in on this. So I think on the political feasibility, given that legislators were willing to pass this kind of open-ended bonding requirement, I think what we're asking for is actually less onerous as a barrier to justice, right? Some pro-housing people just want to say people shouldn't be allowed to sue no matter what. And I think that's wrong. There are cases where, doing something hurts a neighbor's property. I heard of a case in Edmonton, Canada, where a new building that covered a large footprint of a small site ended up flooding and literally destroying the house next door, right? That's a problem. And we have a legal system to deal with that, and it should be able to deal with it prospectively, not just retrospectively. Um, Bonding, I think, to me is exactly wrong in at least if it's sort of at a fixed level, because it creates really, really difficult access to justice for someone who doesn't have a lot of money but does have a legitimate complaint. Um, right? If I'm a retired homeowner with living on a fixed income and somebody's going to do something that's going to destroy my house, I might not be able to scrape together $15,000 for a bond, even though I would definitely get the bond back. Like, that's going to be a challenge. Um, versus if I'm a rich person who just really doesn't want to have, starter homes or apartment building where I can see it from, across my 3 acres of lawn, $15,000 that I'm probably going to get back is easy. And I just have to come up with some kind of, facially not ridiculous set of claims, and then I get the money back. Uh, so to me, it's very, very like it's exactly what we don't want, which is basically what we have in most of the US is that people with a lot of time and money and lawyer friends can use the court system to slow down development in their neighborhoods, and people who don't have those things can't. And that's exactly what we don't want. So it should be pretty easy to access, but only if you have a clearly actionable harm. That's still a barrier, right? Like I'm not saying that most retired homeowners know something about, stormwater runoff, but if you're in that situation, you could call a hydraulic engineer and say like, "Hey, I'll pay you $100, come down to my property, take a look around. Is this going to be a problem or not?" And so then you're looking at maybe $100 or $200 consulting thing, and then if you go forward, $1,000 to file. Not cheap, right? This is not nothing, but that's within most homeowners' means, and it's much more substantive. That tells the judge and the entire system much more about the content of the claims. And then a judge should always have the power to set if they think somebody's being frivolous, they can come in and say like, "Hey, you look like a person who's completely making things up, and I'm going to make you post bond, and you have a lot of means to do it." And judges are able to do that. But I think without a default bond, which we say a small default would be good, and then if somebody's a kind of a case where they probably couldn't file without no bond, then the judge can lower it. And if they look like they're probably frivolous, the judge can raise it. But something like 1,000 or 2,000 as a default bond seems like maybe a good baseline. Like if you think of sort of the behavioral economics of judges don't want to restrict access to their courtrooms. They don't want to be viewed as the bad guy or as taking the side of the defendant. So putting something that's in the middle and then letting them go either direction, I think seems fairer. Um, but yeah, I think this would be a huge improvement, and it would be a culture shift. Um, but I think in a very positive direction. People would see that the legal system is about getting justice, not, war by other means, which is how a lot of people treat it right now.
Yeah, and I agree that, designing the bonding requirements to ensure that there's, to minimize the kind of differential between people of different means who are suing is really important and tricky. But in my mind, the underlying, rationale for these reforms is, we need to ensure that the developer isn't just getting sued because the abutters are stalling until the developer either runs out of money or feels the need to strike a deal with them. And one thing we saw in talking to our interviewees who either were developers or land use attorneys is that a lot of these cases don't get to trial. They rather they're used to get the developer back to the negotiating table. And sometimes it can take, months just to get all the abutters who are suing to sign a memorandum of understanding. And there are again further exactions that may be associated with that. So that sort of negotiated, um, you know, settlement is exactly the kind of thing we're trying to avoid when we say we want administrative standards behind a lot of types of development, or more types of development than exist now in most of Massachusetts.
Okay. We've got 10 minutes until we jump into Q&A. So if there's anything that you guys want to touch upon before we move on to the questions, now's the time.
Can we talk a little bit about state and local environmental standards?
Sure.
So it's a crucial part of the permitting process often when you have a kind of a sensitive site. And cities and towns often adopt their own wetlands and wastewater system standards that are stricter than those of the state. I think Salim can speak more to how Massachusetts might contrast with some other states where there's a different kind of dynamic between the state and cities and towns. But ideally, standardizing rules around wetlands protection and septic systems across municipalities would make it much clearer what developers can and can't do on a given site. So if a city or town is adopting their own wetlands protection bylaw or supplemental rules to Title V of the state environmental code, the state should have to confirm that there's a scientific basis for those additional rules. And this is an area where the Unlocking Housing Production Commission, which was convened by Governor Healy to study housing related reforms last year and release a report um, earlier this spring, they went much further than we did. They suggest essentially disallowing communities from going beyond Title V or the State Wetlands Protection Act at all. A suggestion that the Boston Globe editorial board later called taboo. And I talked to a lot of developers as part of my job, and it's definitely not taboo within the industry. But again, I mean, what we said is at least give the state the final word on whether a certain additional regulation can be adopted at the local level.
Yeah, and it's not just the substance of the regulations, right? So you can imagine there's a state regulation that says, you have to achieve a 100, on some measurable quantitative scale, and one town says, no, 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 we think we're more sensitive, you need to get to 120. And if you publish that, then at least the developer kind of knows what's going on and knows what you're doing. But a lot of towns, we were told, have really squirrely regulations so that like they're doing like weird dimensional things like your leach field has to be so many feet from site boundaries. And so you think that you know what the minimum lot size is if you're doing, say septic, single family on septic, which is a kind of the most common form of housing in a lot of Massachusetts. And I understand why people don't want to overload and go right down to 1 acre everywhere. They probably ought to be building sewer systems, and maybe that's a conversation for another day. But instead of saying, hey, you need a bigger lot size or harmonizing all their regulations, they've got lot size regulations that say one thing, and then they've got septic regulations which do not conform to their lot size regulations. And so as a developer, you're looking at a site and you've got to kind of go out there with a tape measure and figure out what can you and can't you do. It's not at all simple. And simply saying, hey, towns, if you are going to go beyond, yes, you should have a scientific basis, and you should also use the same language and definitions that the state uses, so that someone who is looking at a quantitative standard anywhere in the Commonwealth at least knows what the standard is. So some things we saw are that like some towns have different assumptions on how many gallons per day a particular size of housing use, and like by large factors. And it's like, well, it's really unlikely that like in East whatever they use more water per capita than in West whatever. Um, and in general, anyway, the state definitions are set in a really conservative, like, something like 90th percentile uh, rate anyway. So it's very unlikely that you're going to be going beyond that. So there's just a ton of room for reform there. And then, Cassie, going back to your question about political feasibility, one of the, again, unique things about doing this project for me was that by the time we were done with our research, a lot of our ideas had been introduced in some version or other into bills that are currently before the general court. And that's not because, I mean, I would like to say that's because Andrew is so incredibly influential that, whatever he's writing in his notebook, lawmakers are copying. But that's not the case. It was that we were tapping into a conversation that's ongoing. This is happening inside the Healy administration, in the development community, in the Unlocking Housing Possibilities Task Force, across sort of pro-housing and tenant organizations, and among the kinds of people who read Banker and Tradesman. And those folks are thinking about these things. And we do this as qualitative research. We don't just go and like read codes and come up with our own ideas about how to reform things. We talk to practitioners because practitioners know. Practitioners in government know what's broken. Practitioners on the private side know what's broken. And legislators are listening to them as well. So something like half of these recommendations are before the general court in at least one, so, either more ambitious or less ambitious than our framing. As far as I know, nobody's taken our favorite idea. So tell your favorite lawmaker, shorten the notice window for continued hearings. Um, but depending on the session and Massachusetts lawmaking, the curse of part-time legislatures is that they only have a short amount of time to work in. The curse of professional legislatures like Massachusetts is that they have all year, and so they don't do anything until December 31st. And so, as of now, a lot of states have finished up. Massachusetts, I just looked at my bill tracker, and not a single bill has even had a hearing of the ones we're tracking. So we'll see if any of this goes anywhere. But it won't be this month.
It may not be this year. Okay.
Can I mention one
Yeah.
other aspect of, I'm sorry,
Yes, but in 1 second. I just wanted to tell the audience we're going to be answering questions shortly. So if you have any questions that you haven't already put in the Q&A, please do it now. Okay, go back in.
Excellent. So one thing that I think, in addition to the reducing the notification requirement, might be low-hanging fruit politically, is the idea of having some sort of requirements around training local board members who do kind of conduct more discretionary reviews. And because sometimes I really do think that a lot of the problems we have with permitting procedures that either become too discretionary or involve, unethical actions like illegally imposed conditions can be alleviated with education, right? Zoning and permitting are really confusing and complicated, not just for lay people, but for municipal staff and developers and think tank workers, etc. And in most communities, planning board members and zoning board of appeals members and city councilors are volunteers, right? And training them to recognize both what the state guardrails around permitting are, as well as their own town's process can, you know, take different forms. But the overarching principle is that people who are more familiar with the purpose and scope of each review policy or tool are less likely to create a situation where they're getting sued or the developer is getting sued or there are unethical decisions being made.
Yeah, and
It certainly would
Cassidy,
help
you
with
said
the,
you said
it
you're
would
on the
help with the
Connecticut.
bottlenecking as well. Yeah, I am on the Connecticut, the Woodstock ZBA.
Yeah, and Connecticut has had this training requirement since 2021. So
Correct. Yes,
are you
I
enjoying your
just
training?
joined. I just joined last year, so I have done one of my 4-hour training requirements. I think I have one more. So yeah, and it's really interesting because yes, we are all volunteers, and there's nobody on the ZBA who is not in some way involved with housing. Most of them are contractors, or I think there's a couple of retired contractors, and then there's me, publisher. But I know something. When I was a reporter for the Belmont Citizen Herald 15 years ago, I covered an appeals process for the ZBA for a 40B development. That was very eye-opening. It took forever. It took like a year.
Yeah.
And to your point about the environmental regulations, they were the big problem everybody had was saving the silver maples, which were not endangered. It was just trees.
That's hilarious.
Yeah, it was pretty wild. All right. Any last thoughts before we jump to our questions?
I'm excited for the questions, actually.
All right, let's do it. All right. So this is from Felix. He's our first question asker. The paper talks about third-party approvals for permitting, which are actually already theoretically approved under the building code. You referenced that current outside consultant reviews are incentivized to draw out projects. What evidence was provided for this, as I see this process as potentially expediting the review/comment process? Disclaimer. One of the hats I wear is managing a third-party building department/fire department review company.
Great. Felix, thank you for your service. Yeah, it's a great question. So there's a really important distinction in the third-party review process in who is hiring and choosing the reviewer. And so there's the question of the work getting done, and I think third-party reviewers like Felix have do this work all over the U.S. in all sorts of different disciplines, sometimes in planning and zoning type things, like a subdivision review, even more often in things like building and fire code. And I think the incentives are really different, at least on, and I know less about the building and fire side. I know more about the land use planning side. And none of these are universal, but the incentives are really different depending on who's choosing the contractor. And so when we talk about third-party reviews, we're clear that this is already allowed for the city to hire. So especially if you get small towns that don't have professional staff, they typically have companies on retainer who handle all their work. And for someone in that situation, their incentive, right? I don't imagine that they abuse this egregiously, but I'm an economist. I believe people respond to incentives. Their incentive is to bill the most number of hours, right? They are not going to get more business if the town approves more projects. Um, and people aren't going to switch to them. Like the town already hires them. And so they have an incentive to kind of make sure everything's clear, make sure nobody at the town is mad at them, um, and be really sort of careful on the approval side. And on the flip side, and what we see in lots of cities and states across the country where the developer can hire a third-party reviewer. So this is true where I live now in Montgomery County, Maryland. As long as the reviewer is sort of in good standing with the county, uh, they can review these building plans. And the county actually really likes it because by the time they get the plan, it's cleaned up. The consultants know how to get it into approvable format. They know which questions are going to be answered, and their incentives are to serve the developer well because they won't get hired again if they go nitpicking and looking for trouble. They also won't get hired again if they get the developer in trouble by failing to deal with the serious issues. So, I think both of those options, both the town hiring somebody and the developer hiring somebody, should be on the table. And that's, I think, actually maybe the most outside the box suggestion that we had, because I don't think that's widely practiced, the sort of developer choice third party review in Massachusetts. But it's a really good question, and it's an area that I will, again, especially on the building code side, I confess I know very little, and I would love to talk to you, Felix, and learn more.
Okay. Next question is from David. Looking at housing in a macro sense, most towns want to protect their town character and don't want 20 to 40 unit Soviet style apartment complexes and look at this type of housing as cities just dumping their problems onto suburban communities. Most towns need housing for first time buyers and senior downsizers. An idea that would fit in with this is pocket style neighborhoods. While less dense than 200 unit building, it would fit more community needs and the aesthetics would be congruent with towns. However, buildings are incentivized into fitting 10 pounds into a 5-pound bag and to produce dense housing for profit that doesn't fit community wants and needs. How about more regulations to incentivize pocket style neighborhoods?
Yeah, I'll take this one. So, um, first of all, I think more pocket style neighborhoods are a great idea, personally. I'd say that ref it's more of a zoning reform question than a permitting reform question, what type of development is allowed. But I'll also say that, if, and it's probably the case in a lot of these towns, that if it's just as difficult to get a pocket style neighborhood permitted as it is a giant, Soviet style apartment complex, then developers are going to have an incentive to, have a bigger reward if they're taking the same risk. And so I think one thing we could do if our goal is, more kind of, I'm going to call it missing middle housing or kind of smaller scale multifamily that could be appropriate for a suburban neighborhood more so than, block size apartment buildings, is to make it easier to build those smaller multifamily buildings relative to the larger ones. And I think that there are a lot of different ways of incentivizing that via permitting or zoning or other factors. There's also been talk about reforming building codes to allow, kind of single stair buildings among buildings with fairly few units. But I agree that this is indirectly a permitting issue, and I would like to see more of those style neighborhoods encouraged.
Yeah, well, I think some of the things that we talk about in the paper do go directly to can you build a small lot subdivision, right? Even if the zoning's in place, if the town won't extend sewer and water, then you're going to be hard pressed to get permits to run all that on a community septic system. If subdivision processes are an extra barrier and burden to you, then you'd rather sort of keep the site whole and develop it as multifamily instead of going through subdivision. So making sure subdivision's easy, um, and then likewise, site plan and environmental. Um, if you have to kind of go through these in a for each neighborhood at a small scale and it's a huge hassle, if you think of these as fixed costs, right? If I have to spend 2 years of developer and lawyer time to get any project off the ground, I'm only going to do big projects. Whether those are big projects of lots of townhouses or big projects of um, apartment buildings, I do think it's important to point out nobody is building Soviet style housing in the US. I don't know how much time the questioner has spent in the former Soviet Union. Um, but that's not a building typology that is getting constructed in the Commonwealth. And like the number of kind of dog whistles in this question makes me wonder whether the questioner is like really interested in expanding access to his community in a positive way or wants to kind of create a straw man and say, well, we don't want that straw man in our town. I'm like, well, okay, well, if that straw man existed, I wouldn't want it in my town either. But like seniors and young people who grew up in your town also live in apartment buildings. They're not that weird. I had my first two children living in an apartment building, and now I own a single family house. Like this is a pretty normal succession in American life, and we shouldn't treat it as like, oh, those crazy weirdos who want to live in an apartment. So I think this is pretty important to just be honest about who we are talking about when we're talking about housing.
Especially in Massachusetts when our home ownership costs are through the roof, and so are rents for that matter. So there are plenty of people out there who would love to own a house, but just can't, and they have to live somewhere. Okay. Felix has an aside. He says the billable hours piece is somewhat of a misnomer because many of the third parties are actually fixed fee and incentivized to have fewer reviews.
Good. All right. I stand corrected.
Luke says, do either of you have enough experience working with the Massachusetts legislature to share some theories about why it's rare for them to act on single pieces of tactical cleanup legislation? Many of these are relatively narrow, but smart permitting reform bills. My sense is that other states like California pass dozens of separate housing related bills each session, but we don't.
Yeah, you don't even need to go as far as California. Rhode Island passes about a dozen technical, impossible to understand bills a year. That has to do with the fact that their speaker, the Speaker of the House, is a land use lawyer. Um, and, just like has trotted these things out for his colleagues. They don't understand it, but they all vote for it. Um, every legislature has its own kind of weird ways of doing business. Um, and I don't know why particularly Massachusetts does things the way it does, but there's no constitutional reason it cannot pass small cleanup legislation and maybe interesting legislators and that would be valuable, Luke.
Okay. Sort of in tandem to that, are there any municipalities in Massachusetts that already have the permitting process set up in such a way that state law could mirror regarding site review? I'm going to guess the answer to that is no.
Wait, sorry.
Yeah.
I didn't quite hear you read the question, so I had to go find it myself.
Okay.
We don't know. I mean, there probably are. Um, but for the state, they're going to want to think about if you're writing this into statute, you're going to be thinking about it at maybe a higher level and not quite as operational as a town or city would write it. So I would say do kind of both. Like look at the cities and towns that are doing a good job and make sure that you're not banning what they're doing. Um, but also you're probably going to want to look at other states' statutes and say, how do they draw these guidelines? You want to have a balance between giving towns the ability to kind of run things their way. This is especially true in the Commonwealth where some things like different towns send things before the same things before different boards. So things that are heard by a planning board in one town will be heard by a zoning board in another town and by, the city council in another place, right? So that makes it so you want to be pretty careful. And I think one reason that a site plan review statute hasn't gotten passed is that it's going to be a lot of work for whoever has to write it.
All right, here's another third rail question. This may wrap us up. A major impetus for establishing zoning limits for housing is towns' concerns that school housing will have an onerous financial burden. They only want commercial uses or senior housing. How might we make it easier to allow housing suitable for families or incentivize appropriate zoning?
So this is kind of a recommendation we have in our paper. Um, Allowing school impact fees for by right projects in communities with growing school age populations. It's an idea that's going to be controversial among some housing advocates, but we think it could unlock housing opportunities that would otherwise be met with fierce resistance because of school capacity or other infrastructure or fiscal concerns. Those concerns can certainly be overstated sometimes, but importantly, I think we can minimize the risk to the developer by requiring any school impact fees that exist to be formulaic, not negotiated. Many other states use school impact fees as part of this kind of delicate political balance regarding development and growing communities. And if we expect some parts of Massachusetts to be primed for growth going forward, it may be prudent to allow communities to adopt these fees, even if it isn't a traditional pro-development move.
Yeah, that's right. Um, one of the reasons New England is perhaps the hardest place in the country to build is that the same people who handle zoning approvals also handle school budgets. And that's not the case in most of the US, where school districts tend to be politically independent, right? So where I live, there's a county school district and a county zoning board. They handle the same territory, but they're different people. I elect them separately. And then in lots of the country, the boundaries don't even line up, right? So even in California, several towns will be in one school district, and it's just not the same politics. And so when you're thinking about, hey, these people have to balance the budget every year, and they're deciding whether or not to allow this new development that's going to add a big cost driver to their budget, it's pretty easy to see where their incentives line up. And so allowing some impact fees, I think, is actually really valuable. It's usually viewed as an anti-developer move, but I think it's pro-development. And it's ultimately like things have to be sustainable for everyone involved. We understand that developers won't keep building if they can't make money. And I think we should understand this about towns too, that they're not going to keep accommodating growth if they can't balance their budgets at the end of the day. On the guardrails, I think jurisprudence at the federal level has gotten a lot better here in the last couple of years. So we had the Sheets decision at the Supreme Court. So in California, impact fees have gone off the rails where they're enormous and totally disconnected from the actual impacts of a project. And that the Supreme Court said that's clearly inappropriate, and just the fact that you did it via a formula does not exempt you, which bizarrely some California courts thought that you could like ignore the Constitution as long as you had a formula, which didn't make any sense. Um, and our suggestion also is to say you should only be able to charge these school impact fees if you're doing by right development. Let's create a really big incentive, big fiscal incentive to say, instead of doing things piecemeal where you're fighting it and you're forcing developers to jump through hoops, say, this is the housing that our town will allow. These are the places that we are planning for growth, and we'll allow sewer expansion, blah, 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 to make it happen. And if you build there, you're going to help fund the construction of new schools that will teach your children. And that is a deal that Americans accept all across the nation. The states that are building housing, they have these kinds of fees. And it's fundamental to the sort of the trade-off of like town is going to double in size over a decade or two as the city expands. We are going to need new stuff. It doesn't apply if you are way below your peak student population and you just would like money to, fix up your schools, that's on everyone, right? That's a public taxation issue, and that should not be, where fees go. So I think that's where our, like, if your school age population is above its peak, then you get the right to charge these fees on by right development. And I think that would be a huge culture change. Developers would hate it at first, but then they would find themselves a lot busier than they are now. And I think that would be better for everyone.
Great.
Can I actually, I think further up in the chat, there's a question from Jason about shot clocks, and I think it's
Yeah,
a
I was just going to ask
question.
that one.
Okay.
Okay, so Jason says, does Massachusetts currently have any shot clocks on permit application review times? In other states, have these been useful or are they easy to get around?
Right. So at the state level, I'm not sure the review times themselves are subject to shot clocks, but you do have to either approve or deny a special permit within, I believe it's 90 days of the public hearing being closed. We recommend shortening that to 30 days in our paper, but we're also not optimistic about the efficacy of shot clocks in general. And here's why. So if you're saying, okay, elected local body, you have however many days to make these permitting decisions, as long as it's a discretionary process, the local board or committee has all the leverage they need to delay the decision as much as they want, right? If there's always a threat that the board or committee can simply deny the project, 9 times out of 10, the developer is going to go along with whatever deadline extensions the committee wants. And the alternative is the project probably either gets denied, or at the very least, you've created some bad blood with a group of people that will probably need to approve some of your other projects in the future. And so that's why we're kind of not optimistic about shot clocks and didn't make a lot of recommendations related to them. Even though, as I mentioned from the top, the Pew Research Center's public opinion poll said just require the government to, have the permitting process be faster.
Yeah, right. It sounds so easy. Again, we're going to come back the third time to our idea of like shortening these notice requirements. Instead of saying, we're going to hit towns with a stick that you have to approve things in 30 days, which they're not going to do. They're just going to continue the hearing. Say, hey, we're going to help you speed it up because right now we've got a state mandated delay between every time you can meet. And so like let's take out this like the damage the state is doing first and not be unrealistic, not have sort of unrealistic requirements that people sort of act against their own interest. And so anyway, please read the paper. We were so honored that all of you showed up today, and a lot of familiar names in the attendee list. Great to see everyone. I really enjoyed doing this research, and Massachusetts is a target-rich environment for reform, so there's lots to talk about.
Absolutely. It was an absolute pleasure working with Salim on this work. And Cassidy, thank you so much for moderating. Everyone, thank you for coming. I would like to mention I have a plug for an upcoming webinar of Pioneers on June 24th at noon that will dive into more specific policy proposals already on the docket in Massachusetts around housing, or being implemented currently, including the MBTA Communities Law, featuring a panel of mostly practitioners. So we're very excited about that. It's part of a kind of 4-paper series Pioneer wrote on housing policy in Massachusetts. So, thanks again.
All right. Thank you. Thank you everyone for being here. Make sure you check out Andrew's next webinar and have a great rest of your day.